Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is a community conference call that we hold every other Thursday. Today is May 14th, 2015. I'll go over the questions that have been posted, then invite follow-ups. Let me rephrase that. I will first do the questions I think are frequently asked questions, invite follow-ups on those questions, then do the other posted questions, and if time remains, we'll do new calls. Okay, I am keeping my Twitter account open. If you have any comments or concerns while I'm talking, feel free to tweet me, immigration.com, no dot, immigration.com. You can also tweet me from the home page. On the right-hand side of the home page is our Twitter feed, as is also there on the right-hand side of the forums. So you can actually tweet us from there as well. Okay, let's get started. As when you log in, the recording tells you that this is not an attorney-client relationship telephone call. We are providing information to the best of our ability, not a substitute for a one-on-one consultation. First question is from Romal. He says, I previously worked in USA on H1 for 6 months in 2012. Returned to India, resigned, came back after 4 months for my master's. Okay. Graduated, worked on OPT, unpaid job for 3 months, got paid for the next 3 months. Well, OPT doesn't require paid work. There was some confusion in between where government took the position you've got to be paid on OPT, and they have backed off since then. We've actually won a series of cases where the government did back off, because it's not, regulation doesn't require you to get a paid job. As long as the job is 20 hours each week or more, whether it is paid or unpaid, it doesn't matter. Okay, so let's see. I'm currently working full-time for a reputed employer. Since then, on the same F1 OPT. My OPT expires in August 2015. So I'm planning to visit India for about 12 days. Then I want to come back and apply for STEM extension. Is it a problem because I'm going so close to the end of my OPT? I don't think it's a problem. I think you should be able to travel as long as your I-20 is endorsed for international travel. You've got your pay stubs. Take a letter from the employer that says that they intend to also extend your STEM-based OPT. So I think that should be okay. Normally, I don't like people to travel on OPT, but in your case, it appears to me to be reasonably safe. Okay. Next question. Oh, actually, I made a mistake. I should have gone over the frequently asked questions first. So let me backtrack and go over the frequently asked questions first. Here is a frequently asked question. My parents are visiting. I want to apply for their green card. I'm a US citizen. A bunch of issues that come up. Guys, this is one thing that is very common in many, many cases. Let me go over the issue of applying for a green card when you are visiting on a tourist visa, or even converting a tourist visa to H1 or L1 or even student visa. There is always a problem when you try to do that, because the government can raise the issue that when you entered USA on a tourist visa, it was your intention to convert to a long-term status, which is illegal according to the government. And there's actually a 30, 60-day rule which says if you enter on a tourist visa and you change to a longer-term visa or try to change to a longer-term visa or status within 30 days of entry, will presume it that you had a preconceived intention to do so. And that can be considered to be a fraud, and if you're not able to rebut that fraud presumption, that can become a permanent bar from entering USA because it's fraud. Okay? So if you try to change status within 30 days of entry, if you do it within 60 days, they can still question it, but there's no automatic presumption. If you do after 60 days, they may not question. But remember, this is not a rule cast in stone. Even if you try to change status after 60 days, you can be questioned by USCIS, CBP, or even the consulates about your intention. So when your parents are visiting, it is important that they don't have an intention to apply for a green card when they enter on a tourist visa. If after staying here for 3, 4, 5 months, it so happens that their intention changes, I don't see any problem with that. Remember, you the child or you the son or daughter, what your intention is, I don't care. Your parents should not have the intention to convert to green card. Okay, so keep that in mind. If it is, if they arrive with a preconceived intention to change to green card, they can have a problem. So don't let them have that intention. If after a few months of living here, you are able to convince them to file their green card, I think that's okay. Okay. Their birth certificate contains, before marriage, mother's birth certificate contains maiden name. That should not be an issue, okay? Because having a maiden name is common in USA as well as in India. So I think that should be okay, even though her passport contains her married name, her birth certificate contains her maiden name. I don't think that's a problem. Okay. Two, my parents don't have a marriage certificate. You know, as I remember Indian laws, under Hindu Marriage Act, you are not required to have any marriage certificates. When you are going through a religious marriage, it only has to comply with the laws of that religion. So when you have an Islamic wedding, and Kabul, 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 the 3 times I accept is marriage. When you are going through an Indian Hindu marriage, you are going through the 7 steps around the fire, or the 7 cycles around the fire. That under Indian law is a valid marriage. So really having a marriage certificate under religious laws is not required. Okay. What are the options? You can get you can get affidavits from 2 people who attended the marriage. They can be family members, friends. As long as they were at the marriage, they can give the affidavit. My father does not have birth certificate. You do need to get a certificate of non-availability from the place where he was born. There's no particular format to a certificate of non-availability. All it has to say is that they have looked at their records and there is no record of the birth of such an individual. When you have that, you can then get affidavits from 2 people who were alive when your father was born. They don't have to be adults. The law is they were alive when your father was born. So they can testify that to the best of their knowledge, he indeed was born on XYZ date. So certificate of non-availability combined with 2 affidavits. How soon can I apply for their green card? And I just mentioned that. At least for about 3 months or so, don't even think about it. Then have a discussion with them. And if they want to apply for a green card while they are here, at that point, I think it's reasonably safe. Any questions, follow-ups on this particular issue? No new questions. Any follow-ups, press *5. And I see that a bunch of people just logged in. I am monitoring my Twitter account. You can tweet to me at immigration.com. Immigration.com. Okay, that's my handle. You can also tweet from the immigration.com homepage or from the forums. The Twitter feed is on the right-hand side panel. Okay. Anybody, any question on this *5? No new questions? Press *5 on your phone. Okay. It doesn't look like we have any follow-ups on this. So let's go back to our frequently asked questions. I'm going to go over the frequently asked questions first. Here's another question. How can I get a nanny or a domestic help from India? Folks, it's very interesting that if you come on a non-immigrant visa, you can actually get somebody from India or whatever your home country is on a B1 visa to come with you. So if you came on an H1 visa and you're able to show to the consulate that you had somebody as a domestic help in your home, I think there's a certain period, a few months, like I think 18 months or so. They can come with you. You have to pay them the prevailing wage and this particular member of our community wants to know what is the prevailing wage, you can go to FLC, Foreign Labor Certification, FLC Data Center, flcdatacenter.com, and enter your county, enter your job, domestic help, or whatever that job title is, and see what the salary typically is for a level 1 or level 2 person. Okay, so it is very difficult for somebody who's not on a non-immigrant visa to bring people. US citizens who are posted abroad and are coming back just for a few months can bring their domestic help. Green card holders cannot. People on non-immigrant visas can. In fact, even tourist visa holders can bring domestic help if the consulate so permits. People who are coming for medical treatment on B1 visa can definitely bring domestic help. See, there was a visa called H-2B visa, which is not available for India anymore. H-2B visa is available for those jobs that are temporary and for whom you cannot find workers here in USA. So those visas are given for 1, 2, 3 years. They're not extendable indefinitely. Okay, but it's not available to citizens of India. There are certain countries for which H-2B visa is available, but you have to go through a labor certification process, advertise in the newspapers, show the government you can't find local people. Any questions on the nanny visa issue, guys? Press *5. Nothing new. Nothing new, just a follow-up question on this issue. Once again, I remind you, I'm following my Twitter account. You can tweet to me at immigration.com. Immigration.com, that's my handle. Let's see. We have a follow-up question. Pennsylvania, go ahead, please.
Hi, Rajiv. I have a question. Like you told, for example, they're coming as like a nanny job, and they can come on B1 visa. And if they work for some time, do they need to pay tax, or like is it like any tax exemption or something like that?
Tax issues, you really don't want my advice. In plain language, I suck at tax. So really, you want to talk to your CPA. But let me point out a couple of things to you. It is my understanding that if somebody has lived here for a certain number of days, I don't know whether it's 180 or 190, they have to pay taxes in USA. But many countries, including India, have a double taxation relief arrangement so that if you have paid taxes in USA, you don't have to pay them again in India. Okay. So I believe the taxes have to be paid. The question is, when do they kick in? Talk with a CPA, somebody who does this for a living.
All right. Thank you very much.
You're welcome, sir. Good luck. Okay. Let's see. Do we have any other frequently asked questions? I thought we had 1 or 2 more. Maybe not. Nope, we don't. Let's get started. Back to the questions in the order. The first question I've already answered about Romal, who wants to travel on his OPT. Jerry 2094 says, my I-140 was denied in EB2 because he was a little short of 5 years of experience. His lawyer is trying to refile the I-140 under EB3, but his question is, how can I qualify for that labor certification when I'm a few days short of 5 years? And you are right. You are right. Chances of getting an I-140 approval if you don't qualify with the exact amount of number of years, even if you are 1 day short, they will not approve you. And that's a good catch, Jerry. In fact, just to caution you guys, when I look at somebody's experience letters, it's standard in our office not only to look at exactly 5 years of experience, but we want a little bit more than 5 years. Because sometimes government takes the position, didn't you take any vacations? Okay. So if somebody comes with exactly 60 months of experience, I don't want to use it as a 5-year documentation unless I can account either the gentleman did not or the lady did not take any vacations at all, or they have a few months extra on top of the required minimum. So I agree with you. I don't think you would qualify for even an EB3 I-140. Biswa says, I'm on H-1B since 2012. I-140 approved in August 2014 through the current employer. Planning to switch jobs. Will my priority date be retained? Well, I have mentioned this in my tweets. I have also mentioned this on my blog. I have mentioned this several places. USCIS seems to be slipping back to saying if the old employer withdraws your I-140, we'll take away your priority date. They didn't used to say that, but now they are saying that again. So my concern is if the old employer withdraws the I-140, it is questionable whether or not you'll be able to keep your priority date. Should I file PERM immediately with the new employer or wait for 6 months for ability to pay wages? That depends. I would have to look at the new employer's tax returns. If they have enough money in that fiscal year to be able to support your salary, I would file right away. And remember one more thing, Biswa. In order for you to file PERM, there's almost 4 or 5 months of groundwork involved. So it's not like you can file PERM right away unless they already have ads for the position, job order for the position that you're going for. So the answer to your question, when should you start? Let your lawyers help you. They should help you decide. But you're thinking along the right lines. Ability to pay wages is important. Okay. Next question. Once I answer all these questions, I'll open the floor for follow-ups on the posted questions. And then if time remains, we'll start on new questions. Rajiv MG says, my priority date has become current and I'm really scared if the dates retrogress again. So I can't predict what's going to happen there. I'm sorry. It's been more than 10 months since my 485 was filed. Will it be safe to leave the employer as soon as I get it? Oh, you're talking about once the 485 is approved, how soon can I leave? And I have actually, at the end of these discussions, I've given you links to my discussion on this issue that in my view, if you look at the forum where you posted the question, at the bottom of it, I've given the link to my discussion on this issue in the frequently asked questions. So read that. Bottom line is you're not required to stay with that employer forever. You can leave as long as the date on which you got your green card approval, you did not have a specific intention to leave. Okay. So read that frequently asked question that I have given the link to. Let's go on to the next one. Oh, sorry guys, I'm kind of lost here. Switch to another job, priority date retention. Okay, political asylum. Ken, I am very sorry, my knowledge of political asylum is zero. I don't, last time I did a political asylum case as a favor to a friend was in 1993. That was a long time ago. Okay, we don't do political asylum cases. Our practice is limited to complicated immigration issues and employment and business-based immigration. So, but generally speaking, my husband is not in my asylum application. He's an H-1B employee. His employer is ready to help him apply for his green card. Can I write my name on his I-140? As far as I know, ma'am, there is no reason why you cannot get a green card through him, unless there is some issue in your background that makes you ineligible to receive the green card. It certainly should be possible. Okay, double check with your lawyers who are helping you with the political asylum. From our perspective, business immigration, employment immigration perspective, there is no problem in including you. Okay. Next question is from Jaybird. Working on H-1B for 3 years, visiting India to get married. Congratulations. I intend to bring my wife on H4 after getting my visa stamped. She has an earlier problem where government stopped her, found an email that seemed to be contrary to her stated intention. It doesn't look like they made any kind of fraud finding against her. I don't see any problem with it. It doesn't look like she made any active misrepresentation or fraud. They discovered some evidence in email, but obviously they didn't consider it to rise to the level of misrepresentation. So they allowed her to stay for 30 days. I don't think this is going to be a problem. I frankly don't. Okay. Helix 113, H1B for 2 years at a large financial firm, then transferred H1B to new employer, a university, for 2 years. Now I'm considering to start work for a financial startup. For an employer, it's going to be a fresh company in USA. Do you see any problem in terms of the ability to pay wages? See, for H1B, government has stopped making an issue of ability to pay wages. They used to do that. At least I haven't seen them do it for quite some time, and there is some law to the issue, addressing the issue that they shouldn't question that. Okay. However, green card is a totally different issue. I would give you a rule of thumb. If you want to apply through a startup company or a new company, one of the two situations must obtain. Either the green card salary, the salary that you're supposed to get in future, you're already getting paid that. In that case, you can start your green card right away. But if you're not already getting paid that, you're a few bucks short, you have to wait until there is a 1-year history of tax or tax returns in the company. And if unless there is some other situation, for example, the company has a lot of cash at hand, retained earnings, or money that can be considered to be an asset, in that case, you may not have to wait. But that's the decision you should make with your lawyers. Generally speaking, those are the outlines for what you should be looking at. So H1 doesn't require ability to pay wages, but it does require employer-employee relationship. Somebody should be able to fire you from your job. Okay. Green card, if you're getting paid the future wage already, you can start anytime. If there's a difference, wait for the tax returns to be filed with 1-year tax history, or if there's an extraordinary situation like great deal of equity or cash in hand, maybe that can be worked in. Let your lawyers help you with that, with the timing of the green card. Rohit K says, my wife is on F1, was on F1 2004 to 2007, then OPT, completed her master's degree in architecture. Now she is on F1 again, enrolled in certificate level course in architecture at a different college. See, you can't get OPT again. It is my understanding. You cannot get OPT again unless you go to a higher degree level. So if she goes from master's to a PhD, she'll be able to get another OPT in the PhD. But if she goes from one master to another master's, I don't think she can get an OPT. Okay. Next question is Katraj. How long do you have to stay with your employer after you get your green card? I've already answered that question. I've given you links. Look at this forum at the bottom. On the next page, I've given you links. Second question, the priority date of my I-140 is 2009. Then I changed my job. Second employer applied the I-140. The earlier priority date was not considered. I got my new priority date. Can I apply 485 when the first priority date becomes current? If the old employer has not revoked your I-140, then definitely you can use that priority date. If they have withdrawn the I-140, it appears to be uncertain now whether you can inherit that priority date or not. Government has taken a step back from their earlier position, which used to allow us to carry forward the priority date even if the old employer withdrew the case. Next question, Yelmar 1 came to USA on L1B in 2009, went back in 2013. applied for fresh H-1B in April 2013, but came back to USA 8 March 2014. That means you were outside USA for full 1 year. However, you did apply for and got the H-1 before that 1 year was up. Do you have 6 years of H-1? I think you have 6 years of H-1. I think you have 6 years of H-1. That's my belief. Okay. But don't take a chance. At least 2 years, no question you've got, because you were on L1B before. So apply for a green card as quickly as possible. I personally do think you've got 6 years back. Avik Datta wants to know about EAD processing under L2. So I'm planning to visit my spouse currently in USA under L2 visa. Once I reach USA, I plan to apply for EAD. Can I come back to India? I'm not clear about biometrics issue. Unfortunately, I'm sitting in the Arlington office. Our non-immigrant visas are done through the Stanton office. I would have otherwise called them and found out for you what the formalities for the L2 EAD are. I don't remember off the top of my head. You can always call USCIS customer service and ask them these questions. They're usually good about responding. Okay. Will I-765 be decommissioned due to I-94 dependency? And that's the part I don't understand. Can I come back to India during the processing time of the EAD? See, I am not clear on that either. Normally, when you travel outside USA, when your application is pending, that application is deemed abandoned. Double check this with the USCIS. I'm not sure there's a clear answer to this question. In most of these cases, at least when the 485 EAD is filed, we won't let you travel while that's pending. That's not a good idea. Okay. So, sorry, I have very few details about the logistics of biometrics. I don't deal with that level of detail. So I'm not able to help you beyond that. Super Kings, currently on USA on L1B, that expires on 9th August 2015, 5 years gone. Spouse has an I-140, so I can apply for H-4EAD. Should I go for visa stamping or apply for change of status? See, that's a judgment call. Because we don't have enough experience on how long it will take USCIS to approve change of status and EAD, or whether they can stagger the EAD and H-4 status approvals. So we really don't have too much information on this, but it appears to be quite clear that getting an H-4 stamping from outside USA is quite quick. You can certainly go to a third country. You can go to Canada, Mexico. There is no law that says you've got to go back to your home country for H-4. Okay, so this is called TCN, third country national processing. You can go to any country you like. Okay. User RK says, I'm currently on H-1B visa, live in Baton Rouge. I got a DUI, but I got no conviction. Look, under immigration law, even though under state law something is not a conviction, immigration law can consider certain kinds of actions taken by you and by your lawyers to be convictions. For example, I've seen cases, and I mention this quite often. Last year, we did a consultation for somebody in Pennsylvania where they have something like a diversion program. You don't have to enter a plea of guilty, and if you do community service, etc., and stay clean, they will dismiss the charges without any finding of guilt. Looked quite simple. And when I got retained for an opinion, I said, look, I'm not going to give an opinion until I'm able to talk with the Pennsylvania lawyers who represented you. When I spoke with them, they were quite clear that this is not a conviction. And I said, look, with all due respect, folks, the standards for conviction under, oh, somebody just tweeted to me. Okay. I'll get to, Rajeshji, I'll get to your question in 1 second. I'll get to your question. You were asking your father is not in a position to travel and get non-availability. Anybody should be able to get the non-availability. It doesn't have to be your father. Okay. I'll unmute you in 1 second. Let me finish. As soon as I finish all my questions, I will unmute you first. Okay. Sit tight. Going back to my original discussion. So when I looked at the provision of the law of the Pennsylvania statute, there was actually a necessary implication in the statute itself that said, if you go through this program, it is considered to be a plea of guilty. Or there was something like that. I don't remember exactly what the problem was. So obviously, this is a complicated issue. And even though the conviction is in 2013, there is a potential for a large delay in visa processing. Even if there's no problem with your DUI, let's say it's a petty offense or it's not a conviction. Consulates can put you through psychological testing, psychiatric evaluation for addiction, and that can take a few months. So keep this in mind. Banyan Tree says I-140 was denied in 2011, appeal denied because you have a 3-year degree. So you are asking about the amicus briefs that AAO is asking for. The issue is different. All the AAO is saying is, normally, in an I-140, we don't allow an employee to appeal. It's the employer's application. We don't give employee any rights. Should we be giving them rights? That's the issue. It has nothing to do with the 3-year degree. Okay. So I don't see how that is going to help. Blvd says we applied for advance parole in April, traveling to India in June. In case we don't receive, can secondary beneficiary travel? No. If the AP is pending, nobody should travel. Okay. Next question. That's too many questions. I'm not sure I can answer them all. Let me try to go over them real quickly. But folks, try to keep the discussions short. We try to be fair to everybody. So NZX206 works for a Desi company. EB2, H1B renewal, 1 more year left. Current employer is ready to agree. They won't revoke I-140 for 1.5 years. Got an offer from client. They're ready to file for green card on EB2. Is it a good idea to change to full-time at this time? So basically, should I change employers? I mean, if the old employer is not going to revoke the I-140, sure. How long will it take for H1B transfer? You should do a premium processing, and as soon as the receipt comes, you can join. How soon form is going to be filed from client? I do not know. That depends upon the company. How long will it take to approve labor in I-140? Anywhere from a year or less to 2-3 years, depending upon how much trouble you run into. 2015, May 26 onwards, H4EAD will be approved. If I file for H4EAD with my current employer for my wife, and then I transfer, what will happen? My guess is nothing will happen. She should be able to keep her EAD as long as you maintain status and there's no interruption in your status. That's my guess. If the priority dates are current after transferring H1B to client, who is going to file EAD? Well, you can only file 485 through your old employer if they are willing to keep the job open for you. It'll be a difficult case. I want you to consult with your lawyers. This is not a decision to be made in a snap 3-minute, 4-minute discussion. Go over the options carefully, but it is possible for you to have left the employer and that employer to still retain the intention to hire you back and file a 485 on that basis. Is it possible to transfer EAD to client, and how? Well, once the 485 has been pending 180 days and you have not yet joined the old employer, even if joined them, you can actually join any employer without joining the old employer, or if you've joined the old employer already, you can leave them and take a same or similar job with any employer, without or with joining them. Okay. If the prior, okay, is it possible? What happens if I-140 is revoked? I just mentioned that earlier. I fear that you may not be able to keep your priority date. USCIS has been creating problems about that. Roshan Sharma says, I-485 has been pending 180 days plus, approved I-140 EB2. There was a mistake on the 485, and the mistake is that you were on J visa, but that J was not subject to the home residency requirement. I don't think it's a very big problem. I think you should definitely contact USCIS right away, call them on their customer service line, explain to the frontline people what happened, ask them what they suggest you should do to correct this issue, make a note of the date and time you called, who you spoke with, and what they advised you. Make a note of that, because that's evidence. And whatever they advise you, follow that advice. Okay. So, but act on it. It's a sincere error. It says, I think you'll be okay. Don't worry, but don't waste time either waiting for things to happen. Call them. Let's get to the next question. Question is, can we do cross-chargeability with my wife's parents' country of birth? No. No. You can only do cross-chargeability and inherit priority date from your spouse. You can never do it from her parents. Next question. Samudita says, 485 was pending for 190 plus day with approved I-140 on EB2 rest of the world. I wanted to use AC-21, and what happened was, before AC-21 could be filed, green card was approved. So you are worried what will happen during naturalization. I think you'll be fine. What you should do is just keep evidence, a copy of the AC-21 letter if you're already prepared it. Keep evidence that your jobs are same or similar. Put them together, scan them, keep them forever. If during naturalization this issue comes up, you can show to the government you were going to file AC-21, but before you could, the case was approved. This is a problem with the law and process, not your problem. I think you'll be fine. Ashish wants to know, Form I-765 for the H-4EAD application. I'm under AC-21 rule. I have an approved I-140. So should I file under EAD under 485 or EAD under under H1? I personally feel in your situation, the EAD under 485 might be better. Okay, because H1 can still be shaky, but 485 is a relatively more secure process. That's my judgment call. Okay. Let's look at, you also have a good point. What if I change jobs and I've got H-4EAD? That shouldn't be a problem. What if the previous employer revokes the I-140? Yeah, see, let's see. Maybe I'm mistaking what you're asking. Let's read it again. H-4EAD, I'm on H-1B since Feb 2005 and fall under AC-21 rule. Oh, I see. You have that 1 year H1 extension. So your question is, which category? I think personally, okay, I'm sorry, scratch that discussion. I misunderstood the question. I thought you were eligible to file 485. when I saw the AC-21. What you are saying is, I have a 1-year extension beyond 6 years of my H1, and I have an I-140 approval from a prior employer. Both of these categories I meet. So which one is better to apply for H4EAD? First of all, because we don't have the form yet, I wonder if you could mark both categories. Okay. If you can, that would be the best thing to do. If you cannot, I think you can file under either one of these categories. And my suspicion is, once the H4 is approved, that's what I think the government is going to do. Once the H4EAD is approved, even if the I-140 is revoked, they probably will not take away the H4EAD. That's my guess. Okay. So I'm not sure there's one better than the other. I can't make that decision. Harshi Shah says, we still do not have the updated 765 form and instructions. Do we have any timelines? No, Harshi, we don't. Still waiting. Still waiting. I saw the draft of the new form that was posted, and the draft looked pretty easy to fill. They just had an additional column on the right-hand side for H4EAD folks. So it didn't look that complicated, but we don't have the final. Working in India and maintaining my active green card status. Arjun G, I guess. Okay. I'm expecting to get my green card this year. Planning to work in India for 2 to 4 years. How to maintain green card? Read as much as you can about re-entry permit. Re-entry permit. Don't depend upon returning every 6 months. That's a good idea anyway for your naturalization. But get the re-entry permit, and that is a multiple entry document which allows you to travel as many times as you like, but you're not required to travel even once during those 2 years. So get a re-entry permit, and usually it can be extended for 2 more years. Also look at N470. That might apply. Please read. I have a lot of discussions on this issue already. You can go to our YouTube website, a YouTube site, and the links are on immigration.com. Oh, I see some Twitter notifications. Okay, that's just new followers. Rajeshji, I'll be getting to you in a few minutes. So, Arjun, your question was, will immigration at airport ask any questions? You should be doing re-entry permit. Then you are fine. If I get married in India, can my company or I apply for green card for my wife? Yes, you can. The only requirement is when she comes close to a green card interview, you should be domiciled in USA. Geo 2008, 485 pending more than 180 days, EB1B. Again, the question is about AC21. What if I get approved while I'm waiting for AC21? And I just answered that question for somebody else. Geo, what I want you to do is, if the case gets approved before you can submit the AC21, scan a copy of your AC21 letter that you intended to send, or if there's no such letter, at least some proof that the jobs are same or similar, and keep it just in case it becomes an issue during naturalization. Okay, that's what I would do. There's no provision for sending an AC21 letter after your green card has already been approved. Raj says, in the fall of 2013, I went to a university in USA for my master's, but then there was no funding, not able to secure an assistantship. So I came back. And then in fall 2015, I was able to get funded. I'm out of the US for 9 months. Do I need to appear for the visa interview again? In my opinion, yes. Yes. If in the event I'm required to, will it be a problem? See, I think, Raji, it looks like you came back I hope you're on the phone. I'm not sure how long you stayed here. If you came back fairly quickly, it shows that you had good faith intention not to violate any laws. I think you'll be fine, at least no worse than you were the first time around. And my rule of thumb is very simple. I always tell people, if you're asked any questions, you tell the truth. Okay? Just tell the truth. I don't think you have a choice. That covers us for all the questions that we had posted today. First, let me answer Rajeshji's question about dad. Rajeshji, press *5 on your phone, please. *5. Press *5 on your phone. You had tweeted me. Press *5. Okay. Sir, go ahead. I can hear you.
Hey, Rajiv, this is Keith. Can you hear me?
I can hear you. Are you Rajesh?
Oh, Raj. Oh, sorry.
Okay, no, hang on. I'm sorry. I'm just looking for one particular person. Okay, I don't know where you are. You wanted to know if your father is not in a position to travel and get non-availability of birth certificate, what are the options? Anybody can go. It doesn't have to be him. You could even try calling them. I know it's difficult to do in India. But there may be even companies who run errands for you for some money. You can try doing that. But it doesn't have to be him personally. Okay, folks, no new questions. Follow-up questions on what has been posted. Only follow-ups, no new questions. Press *5. So depending upon how many people there are, I'll be able to or not able to take new questions. I should be able to. There's only one raised hand so far. Follow-up questions, only one raised hand. Okay. That means we'll do new questions after this. We have time. Sir, I can hear you. Go ahead, please.
Hello.
Yes, I can hear you.
Yeah, this is Casey. Actually, this question is a follow-up of your question. Someone was asking how long do we need to stay with the employer after getting the green card?
Right.
So you answered there is a blog which is already existing. I went through that blog and then I had a couple of questions on the follow-up of that blog. There is one more blog mentioned inside that blog which is not working.
Oh yeah, because we changed the software. So we're still working on some of the finer details, including the search. What I do is you may want to do this. I went to Google. That's how I found my old entry because our search engine is still being placed. I went to Google, and in the search engine, I typed where the search is, the search entry is. I typed how soon can I leave, comma, site, colon, immigration.com. So that searches our site and pulls out all the information. So if you just use Google to search our site, and if you're not able to find that, drop me an email to help@immigration.com. Maybe we can record a video, you and me together, and cover all the questions and then post it as a new blog entry in addition to the fact that we have. Okay?
Okay. Actually, same on the follow-up, which does not covered in the video. So actually, I have the priority date of October 15th, 2008.
Okay.
The current priority right now is October 1, 2008, which is for B2.
Okay.
So in this case, it can change my employer now. And then let's say I go to a new employer, and then my priority date becomes current before my new employer files AP21.
Yeah, I have addressed this issue several times today. And what I have said is, if your case gets approved before you are able to file an AC-21, keep a copy of the AC-21 letter and keep evidence that the two jobs are same or similar. Scan them, keep them forever, if the issue comes up 5-6 years down the line during naturalization, you have proof that you tried to do the right thing, but this is a loophole in the law that does not allow people like you to file AC-21. Once the case is approved, there's nowhere to file.
Okay. But I get my green card, right? Though I don't stay with my current employer.
I got it. I understand the question. I've dealt with it 3 times so far today. Okay?
Okay.
Good luck.
Actually, I have one more question, which is in the same line. You mentioned in the video that, in these kind of cases where people change the employer, you can file the citizenship a bit late because they go back only 5 years of previous employment.
Definitely. No, that's not the only reason. Another reason is if you file after 5 years, it is not easy to revoke the 485. Within 5 years, a 485 can be revoked very easily by the government.
Okay. So that 5 years of time frame which you mentioned is the living in US or after 5 years anytime? Or
5 years after 5 years of approval of the AOS.
Approval of 485. Okay.
Okay. I gotta go on to the next one.
Okay.
Good luck.
Yeah, sure. Thanks, Rajiv.
You're welcome. You're welcome. Okay, we've got 2 more folks with questions. I'm going in the order you people logged in, guys. All right, sir. Florida. No, sorry. Illinois. Illinois, go ahead, please. Illinois.
Yeah, hi. I'm actually a consultant, and my H-1B, it completes 6 years in April 2017. My company has applied for the LCA firm to start the green card process. I was just wondering, since I'm a consultant, will my change of, like, if I have a change of location, will I have to file it again?
Oh, see, that's a very, very good question. Normally, a green card is tied to a particular location. Okay. So, back in the 1980s, when the economy became service-oriented economy, and people like you and I who are consulting, it became important for the government to decide what do we do where a consultant gets moved every few months or every few years. Do they have to start the green card all over again? So then what they said was, where the job is subject to relocation, we will consider that job to be permanently located in the corporate headquarters. So even though you are working in Philadelphia and next year you could be working in California, because the corporate headquarters is in New York, the green card can be filed through New York. And then you don't have to keep filing it again and again and again. So if your lawyers are smart and they know what they're doing, they have filed it through the corporate headquarters.
Okay, thank you, Rajiv. I just have one quick question.
Sure.
From what I understand, to get the infinite extensions of H1, you need to file the LCA form before 365 days of expiry.
Yes and no. Yes, in order for you to get an H1 extension, the date from which you are seeking extension, you should have either the I-140 approved or perm pending 366 days. Okay. But here is the interesting part. What if there's a gap? What if there's a 2-month gap? Does that mean you cannot get extension? No, it just means for 2 months you have to make other arrangements. Whether you go to CPT, you go outside USA, or you go to tourist visa. But if there's a gap, your new H1 will kick in after that gap.
Understood. Okay.
Good luck.
Thank you so much.
You're welcome, ma'am.
Thank you.
Okay, let's go on to California. Go ahead, California.
Hi, I'm at CPT as of now. I was working on.
Let me interrupt you, ma'am. Let me interrupt you for a second. This is a new question. I'm going to put you on hold for a second. Let me make sure there's no old questions left over. Sit tight. North Carolina, new question or follow-up? North Carolina. North Carolina, area code 828. Okay. Folks, anyone who has any question, press *5. Those who have already pressed, don't press again, you'll get taken off. Anyone who has any question, press *5. I have 5 people so far, 6 people so far, 7. Okay, so these are the 7 people I'll be dealing with, no more. So please don't raise your hand anymore. We'll run out of time, okay? 7 people is who we are dealing with. Let's start with Pennsylvania. I'm going in the order you folks logged in. So let's go with Pennsylvania first. Pennsylvania, go ahead, please.
Hi, Rajiv. One of my friends, he filed a new H-1B. So when is the lottery selection starts, or any idea about that?
I just tweeted a minute ago that we are still getting receipts. And I think we might keep getting receipts for quite some time. Hershey has a question, by the way. She has tweeted to me, can we trust the authenticity of the draft instructions on the 765? They are good guidelines, but they are not binding yet. So you have to wait for the final form. Sir, go ahead. Did you have anything else for me?
The new H-1B, the last selection, when it will start?
The new H-1B, when it will start, I don't understand what the question is. We are getting receipts so far, as of today, for non-premium cases. Okay. What do you mean by when will it start? I don't understand that question. When will what start?
The government will do lottery selection, right? When they receive more applications.
No,
so do you have any idea?
Lottery has been conducted a long time ago. Lottery is come and gone.
Okay, so how do I know, if I'm selected in a lottery?
You wait for another week or so, maybe another 3-4 days, 5 days or so. At some point, government will announce all receipts have been sent, and you'll start receiving your cases back. When you receive your case back, it means you have not won the lottery this year.
Is there any website or something I can put my receipt number and track it?
No.
Okay, all right. Thank you very much, Rajiv.
You're welcome, sir. Good luck. Okay. Now we've got 5 more people. Let's go to Florida. Florida, go ahead, please. Florida.
Good afternoon, sir.
Good afternoon.
How are you?
I'm very well, sir. How are you?
I'm good. Thank you so much. I have 2 small questions. One is, when 26th of May this month, they're going to open H4 EAD applications. Suppose if you file H4 EAD for a spouse, dependent spouse, and there is another bill parallel going on for the approval. It's not approved yet for filing 485 and 140 parallelly.
Let me correct you. That's not a bill. That's a policy change. Bill is something Congress does.
Say again, I didn't get you.
That's not a bill. That's a policy change from the government.
Okay. So, that bill will pass or not? That's what my question.
That policy change will be implemented or not. See, I don't have any doubt that it will be implemented because President Obama said that he intends to make that change. But how it will be implemented, when it will be implemented, we don't know. Okay?
Okay. On base of this, my question was, if this gets implemented and meanwhile as for EAD also gets approved, and how it's going to impact on the regular EAD if we have not filed that.
Even now we have cases like this where people are on L2, they have an EAD. You can choose your EAD. You can take one or the other. I, at this point, don't have enough information on what is better. My gut feeling is that overall, the 485 based EAD is probably a little better. But I don't know. I could be wrong. Okay?
That will be an open question then. Right?
It's an open issue right now. Yes, sir.
Okay. And the other thing is, I have my name in the Hindi language in the birth certificate. Will it be any problem creating when filing 485?
No, because all foreign language documents can be translated by anybody, like a friend of yours who knows both Hindi and English. What they'll do is they'll translate the document, and at the end of the translation, they'll place the following. They'll say, I'm saying it real quickly, you can listen to the recording. At the bottom, they'll say translated certification. I, XYZ, their full name, do hereby certify that I am conversant with both English and Hindi languages, and that I have translated the foregoing document fully, completely, and to the best of my ability. Signed, dated, no, it doesn't have to be notarized. Signed, dated, full address, contact information. That's it.
So how is they going to verify that the information my friend has wrote that is correct?
How do they verify that you placed a credit card charge? This country is built on trust.
Okay. All right. Okay. Thank you so much. That's what my question was.
Good luck. I actually shouldn't say this country. I think even this is some amount of trust is inherent in civilization. I think it's the same in India, in any developing country or developed country. We have to have a certain amount of trust, otherwise the government can't function. Next question is California. California, go ahead, please.
Yeah, I'm in CPT as of now. I'm working on CPT. I used to work on OPT and I applied for H1 last year and didn't get picked up in the lottery. So I joined another master's, and so I'm working on CPT by both working and studying. So I'm traveling every month to a different state and studying. So I got picked up in lottery this year. So I was wondering, so as I got picked up in the lottery, my city status would change to H1 processing, right? So do I still have to continue studying my master's?
Oh, yes. I think you had left a message. You had tweeted to me, didn't you?
Can you please repeat?
Did you tweet to me? Somebody tweeted me the exact same question.
I'm not understanding.
Ma'am, don't worry about it. Somebody on Twitter asked me the same question.
Yes, that's me.
That's you, right? So yeah, I asked you to just log into the conference. Yes. And the answer to your question is yes, because, well, let's reevaluate this for a moment. In order for you to get change of status from October 1st, it is important that you maintain your status till October 1st. So I think you should continue going to school till October 1st, because you're not covered by the cap extension. That is only for people on OPT, not CPT. Okay?
Yeah, that's the question. Okay, thank you.
Good luck. Of course, you have the option of just going outside USA and getting an H1 visa stamp and come back in September.
That's not possible.
Okay, well, good luck to you.
Yeah, thanks.
You're welcome. Okay, 3 more questions. Let's go to New Jersey. New Jersey, go ahead, please.
Hi, Rajiv. This is Jerome, actually. This is a follow-up question to the one I posted on the forum, which says I-140 was denied in the EB2 classification, and my attorney says he would file it in the EB3. So then I posted the question that if
well, you know,
was denied on the basis.
One thing I must tell you, part of the reason I really like working with all of you is because you are also smart. It just, it's a nice feeling to deal with people uh, who are, on the ball. They know what's going on. It's a very good point. If on the basis of the labor cert, you don't qualify because you don't have 5 years of experience, how is he going to get you through EB3? I don't understand.
Okay, so that's after I posted. He brought up the argument that hey, that one for the EB2, it says clearly that whatever the experience you have gained, it should be post baccalaureate. So that's why on that basis they had denied the petition. But when you file it in the EB3 cases,
good point.
so
Good point. I agree with him. Unless hang on. Unless the language of the perm application says that experience must be post-bachelor's, in that case you will not qualify even for EB3. But if the language of the perm is silent and you actually have 5 years of experience, pre and post-bachelor's combined, I personally think it's still a very bad case to file, because if the government asked a question, if I were the government officer, I would say, Mr. Employer, did you want the experience to be pre-bachelor's or post-bachelor's? Okay, and if they are truthful, they have to say it was post-bachelor's. So the case could still be denied, but it's worth taking a shot.
Okay. Yeah, I mean, it is not mentioned anything on the perm that it should be a post bachelor's plus experience or something of that nature. So he said, since we are filing it in the EP3 classification, it's just that bachelor's plus any parallel experience should be considered and can be considered, and you have almost more than 6 years experience with them.
I would probably not file it, because to me it appears to be, I wouldn't call it a misrepresentation, but it looks little suspicious. Because obviously, what was the intention? If you are trying to file a case under EB2, your intention really is to require post-bachelor's experience. Because if you don't require post-bachelor's experience, then you are really asking for an EB3. So is the government going to get into that? I don't know. I can't predict that. But it definitely is a case that can be pursued. I wouldn't, but I can see how somebody else might.
Okay. So the other question following to this is, can I mean, since I don't have the original labor certificate to file to do the free filing, so I have to request the duplicate copy of the labor, right? So
no. Hang on. That is absolutely incorrect. Okay. Look, the first time when you file the perm application, the I-140, you've got to have the original labor cert. But once the first application has been filed, all subsequent applications can be filed with just an attorney's copy or just a plain photocopy. You don't have to request a copy from the Department of Labor again. No, sir.
Okay. So, on the I-140 form, it says that are you attaching the original copy or not on this application?
You why are you getting into this? Look, if I hire you to do my software development and then I start going over your code line by line, I'm not really helping my work. You are the professional, okay? As long as they're not telling a lie, why are you getting into this level of detail? Let them worry about it. What I'm telling you is the law. They can file it with just a copy. There's actually a memo. There's a lot of disturbance on your line. There's a memo from the government that expressly makes it clear. Now, don't ask me where it is, when it is. It is available. It's out there. Okay?
Okay. So, can I premium process this petition also?
Okay, this is the last question I'm going to answer. The answer is, if USCIS still has the original and they have not put it in storage, they might accept premium processing. That's what they said in one of our meetings. Okay?
Okay.
Good luck.
Okay. Thank you, sir.
You're welcome. Folks, while it's very nice to have people on the ball, at some point you have to trust that your lawyers know more than you do if they are competent. I mean, I can't really say that every lawyer in this country knows more than you do because you have put in a lot of time in your case. They may or may not, but legally, at least law wise, most lawyers should know more than you do. So, like I was telling this gentleman, there is actually a memo from USCIS that says only first time around you've got to have an original perm. Any subsequent I-140s you file on the same perm, you can just use a copy of an office copy of the perm application. Let's go to Massachusetts. Massachusetts, go ahead, please.
Hi, Rajiv. This is Purnima here. How are you?
I'm well, ma'am. How are you?
Good. So my question is, we came in this country in 1999, and my husband is on H-1B visa.
Okay.
Our priority date is September 2004 in EB3, India.
Okay.
And when we came here, my daughter was around 2.5 years old, and currently she's a junior in high school. She's almost 18 years old, but we are stuck in this immigration process. So I have a twofold question. So if our 485 is not filed by the time she is 21, then what are her options? Will she have to file for H-1B visa, or she'll have to go back to India? Is there any way I can prevent her from aging out? And the second question is, she is looking at colleges in Canada and UK as well. So if she wants, can she attend one of those colleges if she gets accepted? And then still, can she remain on a green card process?
Under Child Status Protection Act, the only leeway you have is to be able to deduct the time from her age during which the I-140 was pending. So if the I-140 was pending for 7 months, you've got 21 years plus 7 months to file her 485. Okay. There is no other option to prevent aging out. She has to get into some independent status, whether it is F1, H1, or going to another country. And there's no question of maintaining her on your green card, because once she's 21 and aged out and those 7 months are also gone, she's aged out. There's nothing you can do for her. Once you get your green card, if she's still single, you can apply for her green card as the daughter of a green card holder. But there is no other way around this.
Okay.
Okay. Good luck.
She can, sorry.
Yeah,
she can go to college in Canada or UK and still can be on her green card process.
As long as she's under 21, 7 months, or whatever time the I-140 was pending, she is on your green card.
Okay.
Okay.
Thank you.
You're welcome. Good luck. But do discuss it with your lawyers to make sure all the formalities are taken care of.
Okay. Okay. Thank you.
Good luck, ma'am. Bye-bye.
Bye.
Folks, last question of the day, and this is from Kansas. Kansas, go ahead, please.
So, Rajiv, thank you so much for this informational session. It's really, really helpful. So I appreciate that. I do have a question for you.
Yes.
Are you able to hear me all right?
Yes, I can hear you fine. Thank you.
Okay, thank you. So I'm currently on my H-1B visa, and I'm on my last year of the H-1B visa. The visa expires in March, and I work for a global bank. They're currently okay with sponsoring the green card, although I do have a question around that. Am I still good with applying for the green card, even though I'm on my 6th year of the H-1s?
There's nothing that stops you from applying for a green card even beyond 6 years, even if you are not in the United States. There's nothing in law that requires you to have a certain time remaining in order to apply for a green card. However, are you able to get an H-1 extension without interruption? That's the real issue.
I haven't really talked to them. I'm thinking that it would not be a problem because I do some really crucial work for them. And So that's why I say that with a lot of confidence.
Oh, no problem at all. You can start your green card anytime.
Okay. Having said that, I have one other question for you. So when I studied here, in the States, and I got my master's here. I got hired from the campus, and I worked with them on my F1 OPT from, say, October 2006 to December of 2006, December 31st. My OPT expired, and the H1 quota was closed at that time, and I couldn't work with them anymore. But they still had that project open, and they said that once I had my H1B visa, I could be considered, and I'd work for them. So I had a consultant sponsor my H1B visa because I had that project going. I mean, I had that project was still open, and so I kind of worked with them once I got my H1 visa from October 1st of 2007. And but unfortunately for me, the project, because of lack of resources, got terminated. So my last day essentially was November 2007, 15, or November 15, 2007. I went to India and I got my H1B stamped, and I came back on my H1B. But in the meanwhile, I also received my EAD through my spouse in October. I wanted to know, then I joined this global bank in April of 2008 on the EAD itself. So my question was that would it cause any issues with the green card processing or the permanent form application, having got an H1 then and then started on my EAD later?
Hang on one second. I'm not going to be answering any new questions, folks. People who have raised their hands, this is my last question for the afternoon. I don't want to waste your time. I had already announced I will not be answering any more questions after the first 7 that had been raised. So please don't wait on me. I'm not going to be able to answer your question. Okay, ma'am, you've given me a lot of facts, but I'm not sure what you're asking me. I really don't know what the problem is. You asked me after giving me a whole bunch of facts if this is going to be a problem. In this kind of a conversation, it is impossible for me to marshal all those facts. If you can, in a nutshell, without giving me all those dates, ask me abstract-wise, what is the question, what is the problem? I can try to answer it. But I'm not going to be able to follow all those dates. I need time for that.
Absolutely. I'll just put that in a really nutshell. So my question was that because I came back on a stamped H1B at a time when I didn't have a project in hand, but do you think that
that can be a real problem because if somebody enters USA knowing that they don't have a project, okay, government can take the position that that's a fraudulent entry and a fraudulent visa stamp. That's a very serious issue.
Mm-hmm.
Okay, so it's as serious as the government wants to make it. If they want to make it a serious issue, it can become a permanent bar from entering USA. The law is, if somebody obtains or attempts to obtain an immigration benefit by fraud or misrepresentation, they are barred from entering USA forever. Okay, so are they going to make such an issue? I do not know, but this is definitely a problem you need to discuss with your lawyers and see if there is a way out of it. Full disclosure should be made to the government as and when necessary, but it can be an issue.
Okay, would it be still an issue considering I had an EAD in my hand in October itself?
Well, I think it can still be an issue. And that's where your lawyers come in. They need to look at all the facts. And maybe there's an argument here that despite circumstances appearing to be against you, it really is not a serious problem. I do not know. Somebody needs to sit with you, go over your entire history, and see if there is a good way to handle the situation. But it is serious. You should take a look at it. I won't worry about it, but I won't let it slide either.
Okay.
All right.
So you think I should still go ahead and apply for the firm?
I think you should go ahead and get a consultation from a lawyer. Talk with your lawyers. Talk with your lawyers. Discuss the entire situation. See how they feel.
Okay.
All right. Good luck.
Thank you so very much. I appreciate it.
You're welcome. All right, guys, good talking with you. I kind of run out of steam after about an hour or so. So I'll see you again in a couple of weeks, next to next Thursday. As always, I appreciate this opportunity to speak with you. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.